When you think of perjury, you probably think of a dramatic courtroom trial where a witness is caught lying during his or her testimony. This classic portrayal is just one form of perjury. The Texas Penal Code offenses of perjury and aggravated perjury apply to much more than just courtroom testimony. First, perjury is evaluated based on its materiality, or whether or not it is material. Material means a statement that affects or could have affected the course or outcome of an official proceeding. So, for example, the type of shoes a defendant was wearing may or may not be material depending upon the circumstances of the case. If there are footprints at a murder scene, then what the defendant was wearing that night might be very material. If the crime is drug possession, the defendant's footwear might not be material at all. Or how about the color of the defendant's shoes? If the witness saw a woman wearing pink shoes, then the color is very material. If the witness never observed the defendant's shoes, then it's probably not material. The Penal Code specifies it is not a defense to perjury or aggravated perjury the person mistakenly believed their statement to be immaterial. So there is no defense for a person who rationalizes their lie was minor or less serious than it could have been. A defendant who states, "Yes, I lied, but you shouldn't charge me because I thought the lie wasn't material," can't use this as a defense. The Penal Code states a person commits perjury when he or she, with intent to deceive and with knowledge of the statement's meaning, makes a false statement under oath, swears to the truth of a previously given statement when the statement is required by law to be made under oath, or makes a false, unsworn declaration under the Civil Practice and Remedies Code. So, there are three ways to commit perjury. First, to make a false statement under oath. This can be any sort of setting where a person takes an oath and makes or gives a statement. Second, a person can commit perjury if they provide a statement which was not sworn to and then later, after taking a lawfully administered oath, swear it is the truth after the fact. Finally, a person commits perjury if they make a false, unsworn declaration under the Civil Practice and Remedies Code. All of these offenses of perjury are A misdemeanors. According to the Penal Code, aggravated perjury is committed when a person makes a false statement during or in connection with an official proceeding that is material. An official proceeding can be a variety of different settings, including trials, and may also include administrative hearings, such as before a civil service board or a license revocation hearing following a driving while intoxicated arrest. Aggravated perjury is a felony of the third degree. So, for example, a detective who is a witness during a criminal trial, which is consequently under oath and an official proceeding, who intentionally, knowingly, or recklessly lies and says the defendant was wearing high-heeled shoes that match the bloody footprints found at the murder scene, has committed aggravated perjury because this statement is likely material. How do we know this statement is material? More than likely, the lie would affect or could affect the course or outcome of the trial. There is only one defense to aggravated perjury. The Penal Code states it is a defense if the actor retracted his or her false statement before completion of the testimony of the official proceeding and before the falsity of the statement could be exposed. So, essentially, if you commit aggravated perjury, you better fess up to it right away. If you don't admit to your lie before you finish testifying, or before the opposing party's attorney can confront you with the lie, you don't have any chance of offering a defense. According to the Penal Code, if you have made inconsistent statements in either a previous official proceeding or during the same official proceeding, a subsequent information or indictment for perjury or aggravated perjury does not need to specify which of the two statements was the lie. The Penal Code specifies it is not a defense to perjury or aggravated perjury that the oath was administered in an irregular manner. In other words, you can't claim the judge who administered the oath mispronounced a word or forgot a word, or you don't believe in God, or you had your fingers crossed, or anything else of that nature. Finally, it is also not a defense the document which contained the lie was not sworn to when it contained language it was made under oath. So you can't claim, "I never actually stood up, raised my right hand, and repeated an oath out loud" if the paper you signed, initialed, or otherwise acknowledged has something like, "I declare under penalty of perjury this statement is true and correct to the best of my ability," or "subscribed and sworn to me." Some professionals working in the criminal justice system will tell you the people they deal with lie frequently. In fact, the same peace officers or special investigators might tell you they are used to being lied to, and it may not even bother them all that much. It's just what people do. While most lies are in an effort to avoid getting arrested or to try to spin details in a person's favor, should you lie to certain law enforcement officers or employees about certain things, you might be committing the Texas Penal Code offense of false report to peace officer, federal special investigator, or law enforcement employee. Now, simply lying to a peace officer or dispatcher isn't illegal, but lying about something that is material to an investigation is. Material means a statement that affects or could have affected the course or outcome of an official proceeding. According to the Penal Code, a person who, with intent to deceive, knowingly makes a false statement which is material to an investigation to a peace officer, special investigator, or any employee of a law enforcement agency conducting an investigation commits a B misdemeanor. So, an example of a sort of fairly common case of false report to a peace officer goes like this. A person stays out late and becomes intoxicated. They drive their car home and in the process crash their car. The person climbs out of the wreck and walks the rest of the way home. What do they do sometimes right after arriving home? You guessed it, they call the police and report their car stolen. Reporting your car stolen when clearly it wasn't is certainly material, as that fact would definitely affect the outcome of the investigation. A separate but closely related offense in the Texas Penal Code is false report regarding missing child or missing person. A person who, with intent to deceive, knowingly makes a false report to a peace officer or any employee of a law enforcement agency regarding a missing child or missing person commits a C misdemeanor. Evidence used in any criminal proceeding from the moment of arrest to conviction must be honest and trustworthy, since it may lead to a person being fined, sentenced to prison, or even death. The Texas Penal Code offense of tampering with or fabricating physical evidence makes sure no one impairs or alters evidence in any way. First, don't be misled by the title of this statute. Tampering with or fabricating physical evidence may sound like a high-tech, conspiracy-oriented offense that occurs in the movies, but it applies to a wide variety of much more mundane situations. First, according to the Penal Code, a person who, knowing an investigation or official proceeding is pending or in progress, alters, destroys, or conceals any record, document, or thing with intent to impair its verity or its truthfulness, legibility, or availability as evidence in the investigation or official proceeding commits tampering with or fabricating physical evidence. Next, a person also commits this offense if he or she makes, presents, or uses any record, document, or thing with knowledge of its falsity and with intent to affect the course or outcome of the investigation or official proceeding. This does not apply if the thing concealed is privileged or what attorneys call work product. In other words, it's legitimately confidential. If the thing which is destroyed is a dead body, the offense is a felony of the second degree. All other types of the offenses we just reviewed are felonies of the third degree. The next part of this offense covers a wide variety of situations. A person who, again, knowing an offense has been committed, alters, destroys, or conceals any record, document, or thing with intent to impair its verity, legibility, or availability as evidence in the investigation or official proceeding commits tampering with or fabricating physical evidence. So, this section of the statute would cover a wide variety of acts. For instance, let's say a man is in a public restroom and is caught in the act of using marijuana by a police officer. The man responds to the officer's presence by flushing the marijuana down the toilet. In this case, the man has likely committed tampering with or fabricating physical evidence. He knows an offense has been committed and an investigation is now in progress. He is flushing the marijuana in an effort to destroy or conceal the evidence in the hope he won't be arrested for it, but at the same time is likely committing a second offense, which is tampering with or fabricating physical evidence. Or let's say a man robs a store. During the getaway, he throws the gun he used in the robbery off a bridge and into a lake. He knows an offense has been committed, and the act of throwing it off the bridge into the lake is certainly intended to impair its availability as evidence. The man has indeed committed tampering with or fabricating physical evidence, in addition to the robbery. Another example is a jailer who, upon discovering an inmate has escaped, removes or steals an incriminating note from the crime scene so he or she will not be implicated in the offense. Finally, the Penal Code states a person commits tampering with or fabricating physical evidence if they fail to report evidence of human remains under circumstances where a reasonable person would believe an offense had been committed. All of these types of offenses that we just discussed are A misdemeanors. The Penal Code states it is a defense to prosecution the material destroyed was prohibited under the offense of electronic transmission of certain visual material depicting minor, Penal Code Section 43.261, which, in plain speak, are homemade pornographic pictures or movies juveniles have sent to each other, known informally as sexting, and the material was destroyed within a reasonable amount of time after receiving it. Government records are among the most important in our society. In addition, government records, which are true and accurate, are essential to transparency and accountability. The Texas Penal Code offense of tampering with governmental record covers a wide variety of acts which would make such documents untrustworthy. First, according to the Penal Code, a person commits this offense if they knowingly make a false entry in or false alteration of a government record, or makes, presents, or uses any record, document, or thing with knowledge of its falsity and with intent that it be taken as a genuine record. For example, a jailer who makes a false entry on a log sheet after the fact to indicate a suicidal inmate was checked on when, in fact, the jailer hadn't actually checked on them at the time indicated in the log. Or a peace officer who makes an entry into a report knowing it to be false or untrue. Next, a person commits this offense if they possess, sell, or offer to sell a government record or blank government record with the intent it be used falsely or knowledge that it was obtained unlawfully. The Penal Code clarifies it is an exception to the application of this offense if the record is destroyed in accordance with law. It is an affirmative defense to prosecution. The possession of the false record was in the course of law enforcement duties. So, for instance, a peace officer using a false record for a sting. It is a defense to prosecution the false entry could have no effect on the outcome behind the reason for the record. Finally, it is not a defense the document made, presented, or used had the words "not a government document" printed on it. The Penal Code offense of tampering with a governmental record is a state jail felony if the actor's intent was to defraud. All other general offenses are A misdemeanors. There are many other aggravating circumstances, too numerous to mention here. Consult the Texas Penal Code for specifics.